But going forward, when police do warrantless entries into homes for threats, gun owner, capable of causing serious bodily injury to herself or others, guess what? They're going to be applying this standard here, and it's going to be based on the reasonable beliefs of the officers. Now, we are the Armed Attorneys. Today, we are sharing an important Supreme Court case. This is a 9-0 case that relates to Fourth Amendment rights. We've heard from Edwin. They're kicking the guts out of the Fourth Amendment. Yep. Well, shocker, they haven't changed the trajectory of their decisions, but it could have big implications for gun owners. So we're going to be talking about all that and more. But before we begin, show your support for the Second Amendment by hitting that like button. And if you're not already, join us over at armedattorneys.com. Join the Insider newsletter. It's the one place we can't get censored. There's some bad facts here. Guess what? We know that makes bad law, so we're going to have to self-censor a little bit.
Yeah.
But today we're talking about Case v. Montana, and this was decided on January the 15th, 2020.
Yeah. So in this case, the petitioner's last name is actually Case as well, so it's kind of confusing. But so Case had called his girlfriend at the time and basically said that he was upset and that he was thinking about unaliving himself. And she was concerned because she knew that he had some history of unaliving himself tendencies. She also said that he sounded very intoxicated. He was very worked up. She said that he told her that he was going to write a note saying why he would do such actions. And then she heard some sort of kind of popping sound in the background, and then the line went blank. And so she called 911. She reported that she was concerned that potentially he had unalived himself at this point. And so she actually met the police there. And when they get there, they go around the house. They're shining their flashlight in. They see no sign of him. But what they do see are empty beer cans. They see an empty firearms holster, and they see a notepad, which they say looked like some sort of note that someone would leave before unaliving themselves. And based off that information, and I guess the police had a history with this individual, with Case, and so they stated that they knew that he had mental health issues, or what they are saying, a history of mental health issues, and that he had some history of alcoholism. I guess he had also made some suggestions previously that he would possibly unalive himself with the assistance of police. So basically put himself in a situation where the police would be forced to, to shoot him, to defend themselves is what they would be claiming in that situation. So what ends up happening is that the police make a determination that based off the fact of this 911 call and the empty beer bottles and the empty firearms holster and the notepad, that they are going to go into his home without a warrant to render aid, is what they say. Now, in order to render that aid, they also put on all of their tactical gear because
they spent about 40 minutes getting ready.
Right. So there's about a 40-minute time lapse between the time that they show up and the time that they actually enter his home. And their allegation is that they were so concerned about what was happening and that potentially he was harming himself, but they took 40 minutes to get themselves prepared to go in. So they go in, and when they go in, they end up finding Case in a closet. They said that he opens the curtain, and he's holding what they think is a firearm. And so the officer ends up shooting him because he thought he had a gun. Now, Case is injured, but he is not fatally injured, so he is still alive. And he actually ends up getting charged with assault on a peace officer for having that item after police enter his home without a warrant, allegedly for his own safety.
Yeah, it's a little insult to injury. And how this case comes up, well, he is charged with assault on an officer. He moves to suppress, all of the evidence that they collected. I mean, this is when we talk about, hey, invoking your rights, or they didn't read me my rights, or they searched me without a warrant. This is where we reach the remedy stage of, hey, if they did something unconstitutionally, if they violated your rights, they gathered a piece of evidence illegally, well, here's where the remedy theoretically would lie. It's in a motion to suppress. And that's when you allege, hey, guess what? The government illegally obtained this evidence. Therefore, this evidence and every piece of evidence that stemmed from that illegally piece of evidence should be suppressed. Therefore, well, in a lot of these cases, the government's not going to be able to make its case at that point. They don't get rewarded for violating people's rights. Well, in this case, that would think, all right, if the determination is they illegally entered his residence without a warrant, at that point, boom, all evidence gone. How are they going to prove that, hey, look, he assaulted an officer. But the district court denies his motion. They don't agree with him. He's convicted. Intermediate courts of appeals in the state of Montana, they uphold this. They appeal it to the Montana Supreme Court. They uphold the conviction. They give a little bit of a wishy-washy opinion here because there is a circuit split. And this stems from a previous Supreme Court case from about 2 decades ago. This is Brigham City, and this is where we got it's kind of like, I guess you'd call it exigent circumstances. The police look through a window, they see husband beating the crap out of their wife. Guess what? They got to go in and stop the assault. Okay, so we have, in that case, it was a noise complaint, and there's a little bit more to it. But, there's a circumstance where, all right, exigent, no time to go get a warrant, so we need to act right then without delay. Now, this case gets granted certiorari to the United States Supreme Court to resolve this circuit split. And a handful of courts are saying, you know what, the police need probable cause to enter without a warrant, even under these kind of exigent circumstances or emergency situations. About another group of courts are saying, you know what, we just need this reasonable belief standard from police officers. And the Supreme Court, they say, guess what, this emergency response doctrine that we set up in Brigham, we didn't really outline the parameters for it. It's its own thing, okay? It's not criminal. We're going to go with this emergency situation, but we are going to follow this reasonable belief standard from the officer.
Yeah, which is crazy. Case's whole argument to the Supreme Court is essentially that it should be a probable cause standard. That the police should have probable cause if they're going to make a determination that someone is in danger, basically. So the police would have to show probable cause to believe that someone is in danger and that they have to go in without a warrant. And basically what the court says is that probable cause has always been held as a criminal law standard. And what the court says is that they are not going to transplant this probable cause definition to a what they call non-investigatory situation, which is pretty crazy to me, right?
Yes.
So they're trying to say that they're not investigating something by going in without a warrant. They put on tactical gear in this situation. So you mean to tell me that the police aren't investigating something when they put on tactical gear before they go in? I find that hard to believe, and I think it's crazy that they're saying that probable cause doesn't go to this because it's a criminal investigation standard. I think the police have a hard time not investigating something when they go to any scene. What do you think?
Yeah, well, and we'll throw the case up on screen. So this is case v. Montana. It's 24624, and sorry, it's January the 14th, not the 15th. This was a majority opinion by Kagan, but it's a 9-0 decision. And so, everybody kind of is agreeing on this point. The Fourth Amendment doesn't mean much anymore. Your house, this is one of those places where you should feel extra protection. And we say this all the time, bad facts make bad law. Well, here, there's some pretty extreme facts here.
Yeah.
Right. And so the justices, they get to their decision based on the facts in this case. But what it means for gun owners going forward, you start minusing out some of these facts. Courts are going to be applying this emergency investigation standard, looking into these cases, because look, yes, we got these extreme facts in this case made it to the Supreme Court, but going forward, when police do warrantless entries into homes for threats, gun owner, capable of causing serious bodily injury to herself or others, guess what? They're going to be applying this standard here, and it's going to be based on the reasonable beliefs of the officers. Now, will we get as extreme of facts in this? No. We're going to see these cases pop up across the United States. They're not going to have as extreme effects here. And courts, bound by Supreme Court precedent, they're going to apply the framework laid out here. What would a reasonable officer believe was happening inside? Is it necessary to, is this person a danger to themselves or others? Is there a situation where we need to preserve life? And so we're going to see this applied in less extreme circumstances because that's how it always plays out.
Right. Yeah. It's a slippery slope, it's very slippery. And, the problem is that once the police are in your home, if they see something that catches their eye, they can always say, oh, well, we walked back out and then we got a warrant for whatever we wanted. But in the meantime, they can try to go get a warrant for whatever they might see in your home. So, not having this Fourth Amendment to protect you and protect yourself from the police just entering your home without a warrant because an officer had a reasonable belief that something might be happening, that's pretty crazy.
Yeah, it is crazy, but it's a case we got a lot of questions about it because we will see it abused. I mean, this
Yeah.
is how it always goes. Every time we take a little chip out of the Fourth Amendment, there's not a whole lot left of that. It kind of looks like
No.
Swiss cheese at this point,
Yeah.
but it's always going to get pushed to the extreme and abused. But we needed to bring it to y'all's attention and practical things that you need to be aware of. Obviously, nobody wants to put ourselves in these situations where police are randomly showing up to our houses. But it's how do you guard against this kind of stuff?
No, I mean, this is, the crazy thing. And it's almost, I mean, I hate to say red flag-ish, but that's kind of what it looks like, I mean, you get mad at your neighbor and you call the police and say, hey, I think my neighbor's a threat to himself. I heard him yelling some stuff. And, I mean, people could lie about anything.
Don't give the gun grabbers any ideas.
And then suddenly they're at your door.
Yeah, no, but we don't like delivering this kind of news, but it's important that you folks understand it. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And don't forget to question and comment in the section down below. Until next time, we're the Armed Attorneys.